In view of the aforesaid discussion, this court is of the opinion that no relief can be granted to the petitioner in the present case and the writ is accordingly dismissed.
Apply. Please, Lordship, I like to mention for the unlisted pilot, that is WBC number, WBC filing number 8232 of the 25.
Would you unlisted
Already, yesterday already mentioned, my lord has not listed, my lord.
What is the urgency?
My lord,
See, we have been
my
granting all unlisted this week. Today it may not be
lord,
possible.
this is a eviction matter, my lord. Urgency, my lord. They are respondent side, my lord. They are given 1
If you
week.
can bring it before rising, we'll take it up. But once we rise, we'll not take it up. After the matters are over, we'll not sit.
Obligement.
May it please be Lordship. Lordship, with the consent of the other side, I'd like to mention item number 4 of
Hmm.
today's lecture. Lordship, we have to file our affidavit in this case. Why we're seeking the fact.
No, it's a motion matter. We'll issue notice. Mr. Day, you be here, we'll issue notice.
It is a Lordship. Lordship, may I pray for listing of a writ petition after vacation?
After vacation, motion.
No, Lordship, order.
Orders for what?
Orders for Lordship,
Matter of which year?
25, Lordship.
25, why out of turn listing?
Lordship, that some urgency has erupted, Lordship.
What is the urgency?
Lordship, actually, the matter is related to shifting of Anganwadi center from one place to another place. The construction has already started.
When was it last listed?
Lordship,
When was it last listed?
Lordship, I have to check the date.
Not like this. Out of turn listing for orders, not possible. New matters, unless you can show some urgent, extreme urgency. Yes, next.
Item 1 and 2.
These matters have become infructuous, my lord, to withdraw.
Yes, madam.
Yes, my lord. Lordship, already passed what order?
Heard Sri S. D. Learned Counsel for the petitioners in these cases. Also heard Miss M.D. Bora, Learned Standing Counsel, Corporation Department. Sri P. Hazarika is present for the for number 6 in item number 1 in WPC 183 of 2024. Sri Day, the Learned Counsel, has however submitted that by flux of time, the matters have become infructuous. Para, in view of the above submission, both the matters are dismissed as infructuous.
Deeply obliged.
Much obliged.
Item 3.
May I please?
Yes.
In the meantime, my lord, this matter become infructuous, my lord.
Okay.
Challenge was a reservation of,
Judgment of
not
No,
that
no.
one, not that.
Okay.
This is against reservation.
Sri
reservation not the
Sri
topic
J.M.A.
that-
Chaudhary, Learned Counsel for the
Elim-
petitioners has submitted that after filing of the writ petition, there are certain developments for which the writ petition has become infructuous.
Okay.
Also heard Sri S. Datta, Learned Standing Counsel, PNRD, Sri R. Dubey, Learned Standing Counsel, State Election Commission, and Miss M. Borman, Learned State Counsel. Para, the writ petition is accordingly dismissed as infructuous.
Obliged.
Item 4.
Interim Asylum.
Matter on this honorable court has sought for instructions.
Yes, what is the matter about?
But the matter is that our villages were transferred to Morigaon district, my lord, without any giving us any opportunity of hearing, my lord. We are
What right do you have? Transferred from which? Kamrup district to Morigaon.
district.
What benefit do you have if it's in Kamrup district?
We are much near. We've always
Near?
yes, my lord, and we.
How does the distance matter by changing the name?
I know we have
Huh?
limited right.
If tomorrow this Guwahati is renamed as somewhere Allahabad, will it be an easier access to Delhi?
No, my lord, we have been in Kamrup Metro until now.
How does it make a difference?
But if
If,
no,
show us some prejudice, legal prejudice.
but if we had actually we had come before this honorable court earlier. We were given the liberty to withdraw with the liberty to approach the respondent authority. We did so.
No,
my lord.
first you have to show us, establish a legal right which has been infringed or appears to have been infringed by change of name.
My lord, I know that.
Then
That-
what is there to be decided here?
But if our only let them take a call at least.
Why?
on the
Why?
representation,
And
because
it's not for asking. Writ petitions are prerogative in nature. Discretion has to be applied by the court in an appropriate case.
In an earlier decision by the division bench also, my lord, although honorable court did not interfere. but
Sorry,
said
sorry,
that-
you are dismissing. No, no cause of action. Heard 3 as the learned counsel for the petitioners. Also heard 3 M. Bhuya, learned counsel appearing for the GAD.
Sir.
Para, the grievance of the petitioners is with regard to a notification dated 31/12/2022, whereby 12 number of villages in Kamrup district under the Poschim Mayong Gao Panchayat has been transferred to the Morigao district. Full stop. The primary contention of the petitioner is that no proper opportunity of hearing was given before the impugned decision was taken. Full stop. The petitioner had earlier approached this court by filing writ petition WPC 6384 of 2024, which was however withdrawn with a liberty to file representation. Full stop. As the representation has remained unaddressed, the petitioner has filed the second writ petition. Para. What, however, intrigues this court is the issue as to whether there has been any infringement or even semblance of violation of the fundamental rights, legal rights, much less the fundamental right by such notification. Full stop. The scope of giving an opportunity is minimal in a decision to put certain villages under a particular district which comes under the administrative domain. Full stop. Para. The powers to be exercised under Article 226 of the Constitution of India are prerogative in nature, wherein the discretion has to be applied in an appropriate case, which as this power is extraordinary in nature. Para. In view of the above, this petition, this court does not find the present case fit enough to be entertained, and accordingly, the same is dismissed.
That's okay, much obliged.
I think 5.
Yes,
May I please, Sir, Lordship, matters relating to Lordship, misappropriate of use money, if sanctioned by the government of. Assam.
misappropriation of
Use money, Lordship, sanctioned by the government of Assam under 14 and 15 finance, Lordship. After that, Lordship, I have filed many more representation and complaint. No action has been taken by the respondent.
FIR has not been registered.
No, Lordship.
It is, for
Who are you, madam?
the first time it is.
Who are you?
But I am the blazer.
Huh?
I am the blazer.
Villagers?
Yeah.
Where is your FIR?
Period they have mentioned it is from 1617 to 2223, my lord. In the meantime, 3-4 years has already been passed by, my lord.
Lordship,
Where is your FIR?
Lordship, FIR page 23, Lordship.
23.
Yes.
Yes, let us see.
Lordship, FIR has been filed, Lordship, in the year of 23. And complaint also.
23, page 23.
Yes, Lordship.
Okay, you take instructions, we'll issue a short notice.
Right.
Heard. What is your name?
A. Ahmed, Lordship.
Heard Miss A. Ahmed, learned counsel for the petitioner, who is aggrieved by inaction on the part of the respondent authorities against certain complaints, including an ajahar lodged against the respondent numbers 9 and 10. Full stop. The allegation is of misappropriation of public money by the said respondents. Para, let notice be issued, returnable by 6 weeks. PNRD. 3, S. Dutta, Learned Standing Council PNRD for 1,
1, 3, 7, 8, and 9.
1, 3, 7, 8, and 9. M. Burman State Council for 2,
4, 5, 6.
2, 4, 5, 6. Extra copies, huh? 10 registered post with AD. Madam, you have said misappropriation by 9 and 10.
Yes, Lord.
9 is the secretary.
Yes.
Secretary will keep on changing. Misappropriation will done by a person in his own capacity. Where is that person?
If 10 is the ex,
Not
Excuse
10. We are not on 10. We are on 9 and 10. You are given two names, 9 and 10.
yes,
Who is 9?
9 is the secretary, GP
So
secretary,
secretary?
GP secretary.
So secretary will be as a constant person. 2023 secretary may not be a secretary in 2025. What is his name? Then
But if,
how do you make allegation?
allow me to file a report.
By the returnable date, the it is however seen that though allegations have been made, allegations of misappropriation has been made against respondent numbers 9 and 10, comma, respondent number 9 has not been made party by name. Full stop, para. The learned council has accordingly prayed for time to file appropriate I in this regard. Last of the Yes, next.
I've lost you.
Item 6,
My lord, I filed one arbitration petition before the Commissioner Northern District Tejpur, my lord, in connection with the acquisition of my
That
land.
post is not there now.
But that post is overflowed nowadays. Nowadays, my matter is pending. Where we have to approach, my matter remain unattended till today. That's why I'm before you.
When did you file the arbitration appeal?
2023.
23, the post was there, madam.
At that time, it was there.
It was there.
You take instructions, okay. Part 3 SC Biswas Learned Council for the petitioner.
You are a Kala, as you police take over. You act as. Yes. Tell him. Tell.
Maybe.
Where is your statement?
Lordship kindly peruse page 70.
1770.
70. Lordship, with respect to arbitration, Lordship, arbitration only decides the matters where adequate compensation is not accepted by either of the party. Here,
Yes.
the prayer of the petition is to determine the actual owner of the land, then detailed through appointment of an arbitrary order.
And the compensation amount of 18,53,000
And
after
there are
declaration made.
private disputes also with respect to with
No, you come to page
Private
20,
petition.
21 is the prayer, not 70. 70 is earlier. Come to 21.
21 in this writ petition. You see.
21 is the in writ petition. I am
Yes.
saying
No, in
in
20.
the arbitration petition, Lordship,
No.
Lordship, he prayed for disposing the arbitration matter.
Yes.
Lordship. If land is secured under the NHA Act, Lordship, and under NHA Act, Lordship, kindly peruse section 3G5.
Oh, it is CALA. It is Kala.
Kala is CALA is Kala.
Okay. So here he has approached whom?
He
I
has
approached
approached before
Deacon Commissioner.
arbitrator.
Deacon Commissioner. He is the arbitrator.
But
Arbitrator.
arbitration will not be the appropriate remedy if the involvement of NHI is there.
Well, money has been drawn already by the.
Understood, but
Private
that is not the adjudicating authority.
In that event, my lord, my arbitration petition is still going. Let them dismiss it or dispose it. They must give us some finding.
No, that is not the correct forum.
That
You
is
have
not
to-
the correct one.
No, even if we ask them to obtain instructions, the matter will be delayed.
Very true.
Your correct approach is to the ADC, who is the CALA designated.
Forgot that.
You take instructions on this matter. Heard 3 SC Business Learned Council for the petitioner. Also heard 3 R Borough Learned Council appearing for the NHIDC.
Lordship, here NHA is made party, but in Tezpur, NHA is not implementing any project. This could take NHA detail.
For the NHA, National High Authorities, as well as Miss M. Burman, Learned State Council, para. 3 Borough, the Learned Council has submitted at the outset that the appropriate party should have been NHIDCL, as it is the said agency which is implementing the projects at the region concerned, within bracket Tezpur. He has also submitted that the appropriate authority under the Act is the CALA,
Yes.
whereas in this case, the issue has been raised before an arbitrator. Full stop, para. At this stage, Sri Biswas, the Learned Council, pressed for some time to obtain instructions. List for motion after the summer vacation.
Like that.
Item 7.
Yes, instructions. Registered.
Registered as search of the appeal file.
What is this? Mr. Chauhan, what is this?
My lord,
Mr. Chauhan,
cheated by Payong PX.
Mr. Chauhan, cost.
My lord,
Cost. No way out. You cannot waste the time of this court. Your time may be there. We do not, the judicial time is very precious.
my lord, it was not informed to us.
What in not informed to us? Court, the matter is in the court and you are saying not informed? Investigation done, charge sheeted, and you are saying no investigation? Not even registered?
My lord, it was not informed to us, my lord. Kindly, my lord. So it is,
Then from next time you have to, should be alert.
yes,
So you pay cost. How much?
my lord.
There is no way out. You cannot waste this time of this court. We are not meant for this. At your own sweet will, you'll come to the court and tomorrow will withdraw. Not
My
allowed.
lord, nothing was, my lord, informed to us, my lord.
Okay.
So, my lord, it is.
Heard.
I have no instruction regarding that.
Okay, your client will know. Heard. Sri R.S. Chauhan, Learned Counsel, for the petitioner who had approved this court on the, with the complaint that the Ajahar, which was thought to be lodged on 12/5/2025, was not registered. Full stop. This court, by order dated 18/6/2025, had directed the Learned State Council to obtain instructions, and further time was granted on 25/6/2025, directing the matter to be listed today. Para. When this matter has been listed today, comma, Sri Andas, Learned State Council, has submitted that an entire wrong projection has been made in the writ petition. Full stop. By placing the written instructions dated 23/6/2025 before this court, comma, the Learned State Council has submitted that not only the case was registered as Mayong PS case number so-and-so, under so-and-so, the investigation has also been done and charge sheet laid before the appropriate court. Para. It clearly appears that the petitioner has abused the process of this court by filing this petition. Para. In view of the above, petition is dismissed with a cost of rupees 10,000
No, my lord.
to be imposed,
My lord,
and 10,000
very poor person, my lord.
to be paid to the Lawyers Benevolent Fund. Yes.
My lord,
We could have given 25,000. Yes, next.
very poor person, my lord.
Yes, next.
Item 8.
Account number to Malidim. written instructions be made part of the records. Yes. Yes, what is this matter, madam?
This matter relates to the eviction. Here we have challenged the eviction notice, dated 39/24, issued by the circle officer, Sonapur Revenue Circle.
Yes,
This matter pertains to the Sonapur area eviction matter, Kosutoli village. Admittedly, if lordship comes to page 46 of the.
they said that these are patta lands.
These are patta land, but and this notice is issued, my lord, way back in the year, my lord, on 13/9/2024. Till now, my lord, nothing has been done. I have taken instructions from the district commissioner. He says, my lord, that since they are patta holders, my lord, possibly they will not be evicted as of now. So as of now, my lord,
Will issue notice then.
only notice, my lord.
What is your name, madam?
As Laskar.
Heard Mrs. Laskar, Learned Counsel, for the petitioner who is aggrieved by an eviction notice dated 13/9/2024 issued by the circle officer, Sonapur Revenue Circle. Full stop. The petitioner claims that the land in question is patta, Miadi patta land. Para. On the other hand, comma, 3 R. Borpujari, the learned Standing Council Revenue, has submitted that there is no imminent move for eviction and the notices are of the year 2024. Para, be that as it may, let notice be issued returnable by 4 weeks. 3 Borpujari, learned Standing Council accepts for 1.
One.
Rest, I think, NDAS State Council 2, 3, 4, and 5. Extra copies. Para, till the returnable date, comma, no action for eviction be taken without following the due process of law.
Lordship, the criteria observed, my lord, no imminent eviction, my lord. So far as my lord, patta holders are concerned, my lord. Only that much, my lord.
He is a patta holder.
He is the patta holder.
Only for-
my lord, if there are eviction, my lord, pertaining to other encroachers, my lord, we may.
No, only for the petitioner. There is no
That-
imminent move evictions so far as patta holders are concerned.
I'm so obliged.
Item 9.
Yes,
This last occasion, your lordship, whether the appeal has been considered or not, that was the instruction.
yes.
Part. And the second part with regard to that day, my learned friend has stated that there was a, I think that the mandal has gone for a your lordship, assessment of the, but this person's house is within the boundary. He says that that was not. These are the two reasons that are submitted, your lordship, whether that has been considered.
My lord, that instruction I have received just now, my lord. According to this CDC, my lord, that appeal pending before the CDC, where is, he is not the applicant, my lord. He has making of.
He is not the appellant.
Applicant originally, my lord, as per RTPS Act, my lord, where an appeal has to be filed on rejection of the authority below.
Okay.
But he did not file any application for demarcation.
Oh, he was not the original
I
applicant.
did not file for
He
demarcation.
objected that
I object-
demarcation, my lord. To that extent, he filed that appeal.
Yes.
Secondly, my lord.
No, if he was a party in the original adjudication process,
Yes.
my
it
lord.
is, if he was a party in the original adjudication process, it need not be the only the applicant can file an appeal.
To my limited understand, my lord, I am
No,
submitting.
no, demarcation was sought by other. I was affected.
If he
Therefore, I-
was a party in the original proceeding, not may not be an applicant. Suppose a respondent here loses in a writ petition, he
Right.
can also file an appeal for the
But
appellate court.
So far as scheme of RTPS Act is concerned, my lord, if his applicant is, the application is not adhered to, my lord, then within the after a stipulated time, he can file that appeal before the,
The other side will not have a right.
no, they can object before that.
No,
CDC.
if an order is passed against them,
Right.
what remedy will they have?
No order as such, but it is for the demarcation, my lord, where they have objected. So if any order regarding the title and interest of the issue is concerned, my lord, then probably they have to go for the civil court, my lord.
Okay.
Because in earlier proceeding,
Okay, understood. Then what else?
my lord, second thing is that appeal is still pending because that CDC it was presented before CDC, but that according to Citizens Charter, my lord, it is the ADC concern. So regarding maybe a technical issue regarding issuing of my lord jurisdiction, my lord, on that count that appeal is still pending yet.
Now, what is the status now?
It is pending.
Okay.
Appeal.
You
is
appear
appeal-
for somebody? Okay.
No,
Yes.
it was not.
Now, if you want to address, you can address now, or you can issue notice also. We do not know.
But this kind of notice, this kind of activity by petition states, that is by spending for now, and that is why I came before the honorable.
No, if there is a right to file an appeal, that means this right has to come to a conclusion, maybe by rejection of the appeal or by appeal being allowed. Now, if the process is on the midway, and if some action has been taken, then the appeal that the entire scheme of the things will become futile. That is our only anxiety. We can direct the appeal to be disposed of within. Appeal can be rejected if he is not a competent person.
Thereafter they can.
That it can be done. He's also come with a limited issue.
Yes.
That appeal has to be considered. After consideration, it is up to the that authority. He has to act in accordance with law. It may be rejected, it may be accepted.
CTC has raised an objection on maintainability of that appeal, my lord, but final order is yet to be passed. my
Let
lord.
final orders be passed
That
within 4 weeks.
Lord,
maintain-
Okay. The parties will have the rights to hesitate their.
Yeah.
Okay.
that will be better.
No, that is up to the appellate authority. We are not even entering into the grounds. You may have a very good case, he may have a very good case. We will not express any opinion on merits. We will not like to prejudice the adjudicating authority. Let him take a call.
Report of the circle officer reveals something different, my lord, so it. has to
Everything will be
re-
taken into consideration. We will not say anything.
Yes.
Heard Sri Y.S. Mannan, Learned Counsel for the petitioner. Also heard Miss M. Burman, Learned State Counsel. Sri, what is your name?
Vikram Singh Lahore.
Sri Vikram Singh Sinha Lokor is, who is the respondent number 5, is present in person. Para. The projected case is that by taking recourse, please have your seat, by taking recourse of the Assam Right to Public Services Act 2012, the petitioner
Yes, sir.
has filed an appeal under section 8 within bracket 1 of the said act on 16/6/2025. Full stop. However,
Excuse me.
before the appeal was considered, another notice has been served on the petitioner on the issue of demarcation. Full stop. Para. This court, while taking up this matter on 24/6/2025, had directed the Learned State Council to obtain instructions and also directed for maintenance of status quo till today. Para. Ms. Burman, the Learned State Council has at the outset raised a preliminary objection regarding the locus of the petitioner to prefer an appeal. She has contended that under the act in question, such recourse is given only to the applicant who may be aggrieved by an application filed for demarcation and not to any objector. Three, law court, the law court, the respondent number 5 who has appeared in person has submitted that the entire process has been delayed by one means or the other and prays for expeditious disposal of the entire matter. Para. Considering the facts and circumstances, comma, this court is of the opinion that instead of keeping this writ petition pending, the matter is remitted to the appellate authority to decide the appeal preferred before him on 16/6/2025. Para. The aspect of the locus of the petitioner may also be gone into by the appellate authority and appropriate orders be passed strictly in accordance with law. Full stop. As the matter is long pending, such orders be passed expeditiously and preferably within an outer limit of 6 weeks from today.
Keep your-
Both the
It
parties,
is made clear that this court has not expressed any opinion on the inter se merits of the parties.
parties may also, your lordship, fear, if required hearing they may be hard.
Okay,
That may also.
okay. While disposing of the appeal, the stakeholders may be given an opportunity of hearing.
If the status could continue till the disposal.
In that case, my lord, then state of 6 weeks is a time.
4
limit.
weeks.
Yes.
Time limit may be.
4 weeks, huh? 4 weeks.
Status,
The petitioner, order of status quo be maintained till the disposal of the appeal.
much.
Obliged.
My lord, in this case, the petitioner is a receiver. He was appointed by the AT Assam Tea Employees Provident Fund to manage a garden. What has happened, my lord, is that since I've been appointed as a receiver, I step into the shoes of the owner. But the processed tea, it has to be sold through the Guwahati Tea Auction Center. So we had submitted an application before the tea board, that is at page 50, wherein we had paid my lord, that around 36,461 kgs of made tea lying in the godown. So, and the permission from the tea board is required for the registration of the bank account, also for the GST. So, but the tea board has not acted upon that letter, and the Provident Fund authorities have also written a letter to the tea board, that is at page 52, to act upon it, my lord. My lord, as of now, the tea board, they don't have a council as such. So I pray, my lord, that I may be allowed to take justice steps upon the tea board, and notice may be issued, my lord, as regards my prayer.
Yes, Ms. Sharma, you have appeared for whom?
I'm preparing for the PF, respondent number 3 and
Okay. Okay.
This is for the Silguri Tea State. There's another matter.
Sri S. Count Learned Counsel for the petitioner, whose grievance is with regard to the aspect of sale / disposal of the made tea, full stop. The petitioner is the receiver who was appointed, wide order dated
It's 15 to 25, my lord.
22/5/25.
15 to 25.
15 to 25. Full stop, para. Let notice be issued. Returnable on 23rd of July, 2025. 3 Sharma for
3 and 4.
3 and 4, huh?
Yep.
Extra copies. And Guwahati Tea Auction Center,
That notice has to go, my lord, to listed court.
notice upon the rest of the respondents, namely 1, 2, 5, and 6, be taken by registered post to TD. Even Dusty upon whom?
Dusty upon, my lord, 1 and 2, my lord.
As urgency has been expressed, Sri Khaun, the Learned Counsel, prays for a liberty to serve Dusty upon the respondent numbers 1 and 2. Full stop. Such Dusty, allow Kodima through the routed notice of next date, then affidavit before the next date. You have to file an affidavit Okay.
The other matter is also similar one.
Other means?
There's item 11, that is another garden, but issues is the same, my lord.
And the date of appointment?
Date of appointment, my lord, same, my lord, 15 to 25.
Okay, same. And respondents are the same?
Yes, my lord.
Here also Dusty.
Yes, my lord. Much okay. Obliged.
Item 12.
May it please your lordship.
Yes,
Lordship, before I start, can I bring your lordship's attention to page number 121?
126.
Yes, lordship. I just saw it.
Yes.
It's the same corporate lot.
Respondent corporation means? Is this connected?
Lordship,
this
I'm
matter
paying for a
connected?
similar, this is a similar order.
Then if it is not connected, why?
Then, Lordship, okay, it's okay, Lord. I'm just pointing out, Lord. Sorry, Lord. But if you are,
Just a minute. Please. Okay, let it go before another bench. You have annexed that. Okay. Please before any other bench without me. Item 13.
may I please your lordship? This is regarding acquisition of private land for a road, used for, to go to a temple.
Yes.
That, there is a proposal to acquire this, to widening the road up to 10 meters, whereas that 8 meters would have been served a purpose, and I am at the threshold point of the road. In case of 10 meters is acquired, then my building will be
Yeah.
total, there will be a destruction of my building. And there is a public petition, not only me, there are total 32 people. will be
Mr. Das,
affected.
this is difficult.
Mr. Biketa.
No, Mr. This is difficult.
Of course, but
Difficult.
but
See,
my lord-
acquisition, you can ask for compensation.
but same thing.
Whether it will be 8 meters or 10 meters, it is up to them. Yes, why don't you consider?
My lord, that has been rejected. If any, regarding the compensation, if any less has been paid, the reference is always there.
No, that part we have already indicated to Mr. Das. This matters of acquisition, the scope of challenging is very less. Unless he can show that it is not for a public purpose or there is malafide involved, there is no scope. The only scope is to demand for a claim for an appropriate and fair compensation. But that part has not yet arisen. He is more interested in protecting his property. Can you take instruction? The acquisition has been done already.
Not done yet, not yet done. They have this assessment also, they have done it wrongly. There is a RCC building, 2-story RCC building is standing over my land, but they have assessed that
On the
sometime.
reopening, you take instruction.
They have-
When one notice has already been published.
They have assessed only for they have assessed as Assam type building. In the page number 4, whereas I am living over a land on this RCC building.
3 BK Das, Learned Counsel for the petitioner who is aggrieved by an acquisition process. Full stop. It is submitted that the said acquisition has been sought to be done for widening of a road, and according to the petitioner, such the magnitude of widening, which is 10 meters, is not required.
Yes, sir.
Full stop. Para. Matters of acquisition, in matters of acquisition, comma, the scope of challenge is absolutely limited. Para, be that as it may. 3, and thus London State Council is directed to obtain instructions on the status of the acquisition. Para, list on 16th of July.
Notice under section 7(1) also have been.
That is why you're not passing any orders that way. Let an extra, to facilitate Sri Das, the Learned State Council to obtain the instructions, comma, let an extra copy be served upon him during the course of the day. That's quite difficult. It has gone far. 7 notice has gone. You should have come at the beginning, section 4 notice. Yes, next. You try to have the instructions without causing any disturbance, okay?
Item 14.
Yeah, Lordship, we have challenged the Annexer 7 order, Lordship, along with Lordship Annexer 8 communication, Lordship. And by the order dated 19/5/2023, Lordship, my settlement order passed earlier has been cancelled, Lordship.
Heard Sri R. Fukan Learned Counsel for the petitioner who is aggrieved by an order dated 19/5/2023, whereby the order of settlement of land in his favor has been cancelled. Why are you so late?
Earlier, actually, the stance of the petitioner has
No,
approached, Lordship.
23, the order has been passed and you're here. That notice be issued, returnable by 6 weeks. Revenue, Ms. P.R. Mohanto, Learned Standing Council Revenue, 1 and 2,
3-4 I am.
3, 4, and the State Council, no? Extra copies.
I have an interim prayer, Lordship.
4,
At any point of time, I may be evicted, Lordship. Because
interim prayer for 23 order,
at least my status quo may be maintained because of the 1986, I am staying there, Lordship.
23 to 25, what are you doing?
Okay.
If for 2 years nothing has done, why should we pass an order of status quo?
Lordship, the stance of the petitioner approached before the honorable court wrongly, Lordship. Because for that there is a delay, Lord. At least my status quo.
After 2 years, we are not going to pass any status quo.
Okay.
Next.
15.
State Election Commission.
But my limited prayer that my
Panchayat is not made
representation.
in party.
Huh?
Panchayat is not made a part.
Content is required because I am, my grievance is against the deputy commissioner. He is not disposing my representation matter because false affidavit has been filed by the candidate. That is limited prayer.
Results declared.
Result declared, he has been declared.
Oath
Declared
also has
one,
been
one.
taken.
No, oath has not taken.
Locally, vote one.
No, Only one vote she has.
Okay, we'll issue notice. Heard 3 SC Business Learned Council. But who are you?
I lost by 1 vote.
Okay, you are a candidate.
Yes.
Okay. Heard,
Maintainability,
why?
because you can file a under
Election petition. Yeah, he has filed one.
I can file my representation because the false affidavit has been
No, it says that it is pending before you.
Representation, my lord.
representation.
Only representation.
That may be disposed of. Direction may be given to your commission.
ballot issue notice, keep the maintainability open.
Okay, heard 3 SC Business Learned Council for the petitioner who is aggrieved by the acceptance of candidature of the respondent number 4.
Yes.
Who are the Panchayat elections 2025 held on 2/5/2025 for ward number 8, Noghoria,
Yes.
under 87 number Ilashpur Gao Panchayat in the district of Sri Bhumi. It has been contended that the respondent number 4 had submitted a fabricated HSLC certificate, fabricated education certificate. Para. Let notice be issued, returnable by, no, that's October. Both Sri N. Das Learned State Council, as well as Sri R. Dubey Learned Standing Council, State Election Commission has, however, raised the objection of maintainability by contending that there is a recourse provided, remedy provided in the statute in the form of an election petition. Para. Be that as it may, let notice be issued, returnable by 6 weeks. 3 Dubai for 1,
One, but
1, 3. 2 by Endas. Extra copies today. 4 registered post with AD. The aspect of maintainability is however kept open.
Develop.
16.
Yes, the cancellation of GST is covered by lordship's order, my lord. My friend does not. Otherwise, I have no objection, but the order is of 2022. And his ground is that he has not gone through the portal of the
We
department.
have passed a similar order
Yes, I
two,
give
two,
there are,
3 days back.
but it will
Make the
not,
corrections.
my lord, there are many orders. But lordship, this aspect of the matter, because lordship, it will not prejudice the government, my lord, because if my GST is open, my lord, I have to pay tax from 22 onwards, my lord.
Okay, before the vacation, we should be kind. Okay, make the corrections.
Fine. Recently.
The disposal order.
Yes, my lord.
Okay, make the corrections. Okay, dispose of
Item number 20 is also similar, my lord. 20.
20 also. Huh? R.S. Mishra, SC Kyle, Senior Standing Council, CGST. Please make the corrections.
Deeply.
20 of them, huh?
Can this matter kindly be taken up after some time?
After some time will be a difficult proposition. What is the matter?
It pertains to eviction notices, my lord, that were issued.
Same matter, same connect.
My lord, this is, my lord, pertaining to Dhubri district.
Okay.
Where the certain portion of land, my lord, that has been allotted to APDCL for setting up a solar project. So the other public interest is involved. Nonetheless, my lord, since they are others enclosures, notices have been issued to them in the nature of so-called, absolutely following the dictum of Kalakuddin, my lord. Then thereafter, they were given ample opportunity, hearing was conducted. Then, my lord, reason speaking order were passed. These have been annexed. Now, they have challenged the reason speaking order. Well, the repetition prima facie is not maintainable because, my lord, 147 is available against an order passed by the Deputy Commissioner appeal lies before the Board of Revenue, my lord. So how can they, my lord, come before the Red Court? Because question of facts are involved, my lord. If at all, my lord, this honorable court intends to interfere with the speaking order, factual matrix has to be gone into, my lord. That cannot be.
We can issue notice at this stage.
Yes, yes, only notice, my lord, and keeping the maintainability open, my lord.
After some time, my lord, because
After some time, it will be possible. After the matters are over,
at the end of the list.
let me try. Let us try.
Okay.
But once we rise, you'll not be able to take up.
Yes, sir.
Yes.
Wonderful.
Item 19. Yes, we had taken up this matter the other day.
Yes, my lord.
Gail was not served. Mr. Mitra, we issue notice at this stage.
Yes, yes, my.
Is paying for compensation.
Yes.
Okay.
I have to take instruction also.
Heard Sri S. Burman Learned Council for the petitioners who are aggrieved by non-payment of compensation for acquisition of land by the GAIL within bracket India Limited. It is the case of the petitioner that the compensation has been wrongly granted to respondent number 7 by depriving the petitioner. But apportionment, isn't there a remedy? Let notice be issued returnable by 6 weeks. Ministry of Petroleum. Is CGC any CGC? Petroleum Ministry. Who is there in the court otherwise CGC? SS Roy? He's there. Sri RKD Chaudhary, Learned Deputy SGI. Accepts notice on behalf of respondent number 1. Sri S. Mitra. Respondent number 2, Gail. Industries and Commerce Department, A. Kolita. Where is A. Kolita? A. Kolita. Respondent number 3. And 4, I think, 4 also you can take, I think.
Yes. Competent authority is it's a quasi-judicial body, so I think this should be lifted by government.
4 also, I think, Burman. 4 Burman, 5 Burman, 6 Burman, 7 registered post petition.
I get respond. Hello, my submission is that whether this petition maintainable or not, just to get open.
The aspect of maintainability of the writ petition is however kept open. Wherever লিখে দিবা, Sri Mitra, Learned Counsel raises the objection, issue of maintainability. Yes, next. Also 4 registered post petition.
Yeah.
4 and 7. Yes, item number 21, yes.
May I appear with it? Lordship, the petitioners are the cultivator, Lordship, and they were doing cultivation on that land from last 20, and they have no other land. Lordship, suddenly on 26th and election notice was sent by the respondent, Lordship. Eviction notice, Lordship, page 14 and 15.
Eviction for what? These are VGR land.
It is Actonial land.
Huh?
Actonial land.
No, is it VGR?
It has not been mentioned, my lord, it's a visual land.
We issue notice, take instructions, nothing has been disclosed here. Where is the notice?
Notice is page 14, Lordship, 14. Translate. Photo convert.
Directed to ADC,
Page 34 for time being, my lord.
Industrial Development Corporation. What is your name? Your name?
P. Burek.
Heard Sri P. Boragi, Learned Counsel for the petitioners who are aggrieved by a notice dated 26/2025, by which the petitioners have been directed to vacate the land. Full stop. It is contended that the petitioners are landless people who are cultivating over the aforesaid plot of land. Para? The notice reflects that the land is sought to be allotted to the Industrial Development Corporation. Para? Let notice be issued. Returnable by 6 weeks. 3. Miss G. Hazarika, Learned Standing Council 1, 2 and 3, and thus
2, 3.
2 and 3. Considering that the petitioners, considering the case facts projected, it is provided that till the returnable date, status quo with regard to the possession of the land in question be maintained.
Let it be 4 weeks, my lord.
4 weeks, okay. 4 weeks.
I leave.
22.
Yes. Mr.
I'm challenging my lord, the order project my lord 28/24 on the ground of violation of section 73(4)(b, my lord. My senior friend has informed me that issue has been now pending before the honorable apex court, my lord.
Will issue notice at this stage?
So, but
Heard Sri R. S. Mishra, Learned Counsel for the petitioner who is aggrieved by an order dated 28/6/24,
my lord.
by an order in original, order in original dated 28/6/2024, passed by whom?
Respondent number 3, my lord.
Passed by respondent number 3. Full stop. It is submitted that there is gross violation of section 73 within bracket 4 capital B
my-
of the
Finance Act 1994,
Finance Act 1994
my lord.
and the jurisdiction has also been questioned. Para. Sri S.C. Kyle, learned Senior Standing Counsel, CGST, has, however, submitted that the issue involved is presently before the Honorable Apex Court. Para. Be that as it may, let notice be issued, returnable by 6 weeks. Sri Kyle, the learned Ministry of Finance, CGC. No, Finance, CGC. RKD Chaudhary,
He's here in court.
RKD Chaudhary 1. Then rare 2 and 3, SC Kyle, extra copies.
Some protection built in, my lord, because it is already pending there, my lord.
What kind of protection?
They may recover 49 lakh rupees from me, my lord. Some will no possible.
9 of this order may be continued.
Yes, my lord. The first court has said it should not proceed with the final disposal, my lord.
Till the returnable date, no coercive action be taken against the petitioner.
Deeply obliged, my lord.
23.
Yes.
Milord, this application is filed against Milord order of Revenue Board, Milord. And Revenue,
Security caveat, Mr. Morris?
Yes, my lord.
Yes.
the Revenue Board has set aside the order of the Deputy Commissioner on the ground that they have not got the opportunity to act, Milord. Because on the date fixed, they did not appear. And additional District Commissioner has proceeded without hearing them. Now, Milord, at the time of passing the order, the learned board has framed 3 issues for its decision. 2 issues on the merit and 1 issue on the natural justice, on the point of natural justice. 2 merits on the merit, the points on the merit was decided in my favor. And this was set aside only because he was not given opportunity, ample opportunity, or he have not got opportunity to declare his case there. Now, my lord,
Mr. Ahmed, did you appear before the board? Obviously, that is your appeal.
yes,
Your appeal, but your case that you are not given a proper hearing by
Yes,
the
madam.
ADC.
Yes, my lord. Yes.
Now, if the issues on merits have been answered in favor of the present petitioner, where is the scope of the ADC to again hear the matter?
And my lord, in this case, what happened, my lord?
Rather, you should have been.
Again, three.
Rather, you should have been aggrieved. Have you filed any writ petition?
My lord, I approached the revenue board, and the revenue board.
No, after the revenue board, 3 issues have been framed.
Yeah.
What we have heard from Mr.
I
Sahu.
listed the order, my lord.
2 issues on merits have been decided in his favor. You are not aggrieved.
No, my lord, ultimately,
because set
is
aside,
in favor of me, my lord.
because set aside he.
My lord, what happened in
Now,
this
can the ADC say something on merits? What the above what the board has said, ADC cannot say.
case? In this case, what happened, my lord?
Okay, we'll issue at this notice at this
Yes,
stage.
Milord, only status quo I pray for, because
Okay. Heard Sri S. Sahu, learned counsel for the petitioner. Oh, there is a caveat.
Yeah.
Heard Sri A. M. Ahmed, for the caveat, caveat discharge. Heard Sri S. Sahu, learned counsel for the petitioner, who is aggrieved by an order dated 24/4/2024. Why have you come after 1 year?
number 25,
Huh?
25 million.
You've written 24. Come to the synopsis.
Yes. 24.
Wrongly.
24 or 25?
25 million.
Are you sure?
Yes, Milord. The imbuing order itself is that page, Milord, 67.
We are going by your synopsis.
Yes, Milord.
It may be 20,
There is typing mistake, Milord.
it may be 24 also.
24,
Order dated-
4/25.
Order dated 24/4/25 passed by the learned Assam Board of Revenue in Revenue Appeal number so and so, 24 RA N/2023 Salaba. Full stop. It is the case of the petitioner that the appeal was preferred by the respondent number
Respondent number 3, my lord.
3 on the sole ground that he was not given a hearing by the authority, full stop. It has been submitted that while the said ground was held in favor of the respondent number 3, the other issues on merits have been decided in favor of the petitioner. Full stop, para. Let notice be issued, returnable by 6 weeks. Revenue, Miss G. Hazarika, Revenue 1, 2 by
Lord.
H. Sharma, additional senior government advocate. 3 by A.M. Ahmed, Caveat, 4 registered post-it AD. Para, heard the learned counsel on the interim prayer, para, till the returnable date, comma, status quo as on today,
Yeah.
be maintained.
Obliged.
Item 24. Yes, now you have come.
Yes.
Same case.
Same case, same case.
Well, what is your grievance now?
My lord, my grievance is, my lord, on last occasion, if your lordship remembers, I fairly submitted before this honorable court that the
Even on
matter-
the only on the last occasion you have submitted fairly. We thought you submit
No,
fairly
no,
on
in
each
respect of
occasion.
this case, no, in respect of this
We-
case,
We have to be
Because-
very careful now.
my lord, other side did not mention about the matter was taken up by the district authority. I projected the case, my lord. Now, my
It has been decided against you.
no, your lordship has given one-liner, my lord, that has now created all the problem. Now those people are in the baranda only, my lord. My lord, I am repeatedly asking, my lord, as your lordship is aware, the 111 read with 62, there is a procedure, my lord. 62F is the procedure where it
No,
has-
yeah, you will be given copies. Why should
No,
you
it's not
find-
given, not given.
Yes, copies he is entitled to.
I'm entitled to the copy of the complaint, my lord. On the basis of that, I'll make my submission. They are not giving in spite of my repeated request. Written applications are given, my lord.
Or have you come to this court only to prolong the proceeding?
No, not at all. I would like to, your lordship may dispose of the matter also with the direction. No intention to, because if your lordship looks at the notices, I can take the advantage of the notices, my lord. The notices are signed on 16 but dated 18. Is the cyclostal copies. If your lordship wants to look at one, annexes 6 and 8, your same thing, dates are different. Even the officer's signature is also same.
Yes, what do you say? We can dispose this off
Lord,
because pending this will again delay the matter.
Lord.
Private respondents are not here.
No, over here I'm not against the private response.
Heard Sri J. Abidin, learned counsel for the petitioner. Also heard Sri H. Sharma, learned additional senior advocate.
Respond 3.
Sri, you are also there, Mr. Datta?
Yes.
Sri S. Datta, learned standing counsel for PNRD, and Sri R. Dubey, learned standing counsel, State Election Commission, para. Considering the limited grounds on which this writ petition has been projected and as agreed to by the learned counsel for the parties, comma, the same is taken up for disposal at the motion stage itself. Para.
Lordship, I am for 3 and 4.
We are only saying state, we are not giving any response number. Para. Please have your seat. As per the facts projected, the petitioner is an elected member of ward number 7 of the Rongamati
Yes, my lord.
Gaon Panchayat in the district of Dhubri. Such elections were held on 11/5/2025.
Election was held on 7, my lord. Result was 11.
Such election, the results of the elections were declared on 11/5/2025, and the communication was issued on 12/5/2025. Para. However, one MS Minu Begum, who had received the second has vote, had filed WPC 3535 of 2025, challenging the election of the petitioner. And in the said case, this court, while issuing notice, had directed that pendency shall not be a bar for the authority to take an appropriate decision in the matter in accordance with law. The respondent number 4 had issued notice dated 16/6/2025, whereby the petitioner was directed to attend for a hearing scheduled on 18/6/2025. However, on the said date, due to medical reasons, the petitioner could not appear, and accordingly, the next date was fixed on 26/2025. Full stop. The petitioner's grievance is that on his appearance, no copy of the complaint has been served upon him, and the petitioner has been compelled to make his submission in one page. Full stop. Sri Abedin, the learned counsel, has submitted that the aspect of giving a hearing has to be given a reasonable meaning and cannot be made turned into a mechanical process.
May I have, the date was fixed on 20th of June. That has already gone. My learned friend stated that on that date, the hearing could not taken place because of the absence of the deputy commissioner. That may be reflected otherwise. If the
Where has that been said? That has not been said. What happened on 20?
On 20th, my lord, the ADC, not the deputy commissioner, the ADC who has issued the notice, I asked for a copy of the complaint so mentioned in the notice. Then he said, no, you give a one-page writing.
No, where is the statement that no final orders have been passed till now?
No, my lord, no final order has been passed.
where is the statement?
No final order has been passed. And
Where is the statement?
my lord, para 10,
Please read.
that the petitioner explicitly, the petitioner informed that he will submit, para 9 was to give that one-page writing, my lord.
Yes.
And submit that one-page written submission through his engaged counsel, but the respondent number 4 asked the petitioner to write by himself.
No, where is the statement that till now no order has been passed?
The said respondent informed the petitioner that he will be called again for hearing.
Okay, I'm going to say কি cluster to কি করলো?
And the hearing has to be finally
Huh?
taken up by the deputy commissioner, the district commissioner.
Has submitted that till now the hearing has not taken place. Para? Sri
My lord,
H. Sharma.
only one thing, my lord. I've submitted that hearing did not take place by the authorized officer. Because the district commissioner has to take the district commissioner.
Hearing
was not-
has not been taken by the authorized competent person till now.
Yes.
Para? Sri H. Sharma, the learned additional senior advocate, has however submitted that on the aspect as to whether the hearing has not been done is not specifically stated in the writ petition. He has also submitted that the last date was fixed on 26/2025 and the developments thereafter has not been stated in details in the writ petition. Para. Be it as it may, in view of the above, comma, it is directed that in the event the hearing has not been done, the petitioner is to be furnished with the copies of the complaint which finds mention in the notices dated 16/6/2025 and 18/6/2025, and thereafter give the petitioner an effective opportunity of hearing. Full stop. This order is, however, subject to the aforesaid, subject to the clause mentioned above, that the hearing has not been concluded in the meantime. Para. With the aforesaid direction, the writ petition stands
My lord,
disposed of. Para. It is made clear that in case of further grievance, the aggrieved parties may approach the appropriate forum.
my lord, only thing if your lordship permits, my lord. Knowing that, my lord, I am directly elected. My lord, what I'm saying that I have not faced the deputy commissioner who is the authorized officer. My lord, irrespective of the hearing or not, let them give me the copy, and within 1 week, your lordship may mention in the order.
No,
I'm not trying to
that
prolong.
in this petition, without the details, we cannot. Suppose tomorrow Mr. Sharma comes up that this was the order passed on 22nd, today is 27th. We cannot preempt. If you are aggrieved, if there's an order, you can come later. That is why I have said, in case of grievance.
Yes, ma'am.
This order is only conditional that no hearing has taken place.
Right.
Next.
Item 25.
Admission.
Deeply obliged, my lord.
Yes, admission case.
May I tell you, lordship, as per my instruction, my lord, no,
Yes, no,
no
I think this can be
settlement was
disposed
done,
of.
my lord.
Mr. Sharma, last occasion you had given this.
Yes, lord.
Yes, my lord. As per my instruction, my lord, no settlement was done, my lord. Only physical inspection was done, my lord. Nothing,
No, it is based on his written instructions.
yes, my lord.
The written instruction says that apart, your bona fide land would not be damaged.
Yes, my lord. But as per this instruction, my lord, no action has been taken, my lord.
No, we'll say that we'll make it a part of the order. Whatever is your bona fide land, that will not be damaged.
I have another set of instructions. The petition is encroached of the broken task.
No, whatever the enforcement is there, you can go ahead.
Regarding if there is any patta land, we will not touch that.
We will
lord.
not touch.
Yes.
He can get protection only for patta land, not for
Yes.
government land. Heard. Three. H.L. Askar, learned counsel for the petitioner. Also heard Sri H. Sharma, learned additional sinners, and Sri D. Gogoi, learned standing counsel, Forest Department. Para. The facts projected is that due to extraction of sand and stone from the riverbank of Larang River in the district of Kachar, the plot of the land belonging to the petitioner is being damaged. The petitioner has also given the schedule of the land, which comprises of 7 bighas, 3 kathas, 8 chataks of second RS Patta number 2, dag number so and so. Wrong flag maras. In this case, notice was issued on 10/2/2025 and instructions were directed to be obtained. Para. When this matter was taken up on 26/6/2025, the learned State Council had placed before this court written instructions dated 28/3/2025, whereby it appears that the bona fide land of the petitioner would not be damaged. Para. Sri Gogoi, the learned standing counsel, Forest Department, has, however, submitted that apart from the patta land of the petitioner, government land are encroached by him. Para. Be that as it may, in view of the written instructions dated 28/3/2025 placed on record, this writ petition is disposed of by directing that while the authorities would be at liberty to take action so far as the encroachment is concerned, comma, the patta land of the petitioner is not to be disturbed. Para. Writ petition accordingly stands disposed of. Yes. Item 17. 17.
They have put to challenge your lordship two orders, your lordship.
Hey, city won't put.
There are. What
Yes.
has happened in this case, your lordship? Earlier, your lordship, there is an process of eviction of the present petitioners, your lordship, along with some other persons, your lordship, and those persons include some of the patta holders also, your lordship. Then they came before this honorable court, your lordship, and honorable court was pleased to issue notice, and those cases are presently pending, your lordship. And it will be the. In the meanwhile, your lordship, what has happened after filing of those cases, your lordship? Initially, there was no formal notice, only there was a lordship announcement through microphone, your lordship, asking the people to vacate the land. Then, your lordship, on 5/5/2025, your lordship, at page 35, certain notices were issued, your lordship.
Yes.
So far as only in respect of those people who are occupying class government land, lordship, not against the patta. Then, your lordship, page 35, your lordship will get the notices, your lordship. And on the basis of that notices, your lordship, we have submitted our replies, your lordship, to the so-called notice, your lordship, and ultimately, your lordship, will find the impugned orders, your lordship. There are two orders, your lordship. First order, your lordship, that is the page 62, your lordship.
62.
Two orders, your lordship. First order is, your lordship, relating to rejection of our claim, your lordship, under Basundhara 2, your lordship.
Yes.
This order, if your lordship read, your lordship, the speaking order, your lordship,
This you had prayed for settlement.
we have prayed for settlement. And initially, your lordship, there was, your lordship, in website, there was only a line that they have been rejected, possession disputed. This was the line, your lordship. Now, when this honorable court put certain questions to them, how can you pass such an order without having an, then they come up with this order, your lordship. Now, ultimately, your lordship may kindly come to last paragraph of this order, your lordship.
Yes.
And whereas upon careful examination of your applications by the undersigned and the supporting documents submitted thereon, it could be conspicuously inferred that your petition does not fulfill the criteria of acceptance laid on MB Mission Basundhara 2 guidelines, as possession of the land is disputed as per LRA report, and the self-declaration submitted by the petitioner states that applicant has been residing in the applied land since 1/1/2002, and there is no other supporting documents to prove that the petitioner is residing in the applied land for the last 3 generations or more as on 1st January 2022 for the purpose of entitlement of getting settlement under MB2, your lordship. Now, here, your lordship, there is two problem with this, your order, your lordship. The foundation of their case, your lordship, we don't have that. We are not required to prove that they are in that place for 3 generations. Number one, your lordship. If your lordship goes to see the land policy as amended by this notification, your lordship, of 2022, your lordship.
Okay, now that is your one submission, not required.
Not required.
That is not a precondition.
Lordship. What
Okay.
is required, your lordship? 3 generation in Assam, your lordship. That is what is the requirement, your lordship. Now, your lordship, on the basis of this, your lordship, they have rejected. Secondly, your lordship, the ground that
Yes.
possession is disputed is self-contradictory in view of the fact that they themselves has issued notice to us
saying that you are possessing and unauthorizedly occupying certain portion of government land, your lordship, and therefore you are liable to be evicted under Rule 18(2). Now, on the one hand, they are saying that
No,
we are
that is not in the context of present position. That is the context of continuous position.
lordship.
And that submission we cannot accept because that will not have any meaning. When you
Your-
are being given a notice to vacate
Lordship.
and saying that you are not in possession is disputed. Position, not the present position for the required period of time.
Lordship, no, your lordship will kindly see the line, your lordship. Possession of the said land is disputed as per LRA report. That is what, your lordship. Possession is disputed, your lordship. And land revenue authorities report, your lordship. If possession is disputed means, your lordship, and then, your lordship, there is N. The second part is separate, your lordship.
Okay, then
Then, your lordship, on the basis of this, that has been rejected, your lordship. Therefore, we are challenging this, your lordship.
Yes.
In the meanwhile, there is another order, your lordship. Based on this, your lordship, since earlier they have not issued notice, on 5/5 they have issued a notice, and there is a speaking order passed at 5 series, page 74 by the Deputy Commissioner Dhamaji, your lordship.
5/6.
Page, this order is dated 26/5, your lordship.
What page?
Page 74, your lordship.
What does it say?
It says, your lordship, since, your lordship, my prayer has earlier been rejected on the ground that I have not been able to prove that I am there for 3 generations. Therefore, you are, I have no right and bona fide claim, and I am liable to be evicted, your lordship. These two we have challenged, your lordship. Your lordship will kindly see, we have challenged this by way of this proceeding, because, your lordship, other cases we are filing, your lordship, we are seeking relief is presently pending before this honorable court. That is why we are filing this writ petition and fearing the lordship imminent evictions from that particular land, your lordship. Now, your lordship will kindly see if, your lordship, this finding in the very foundation of their subsequent order is the order dated 17/5/2025, your lordship. And if that, your lordship, is not as per their own policy, your lordship, the subsequent order based on the
Yes, Mr. Board President.
Well, the earlier writ petitions were filed, where my lord, where no notices as such were issued, on the apprehension that they might be evicted, on the strength, my lord, that some public announcements were made. In those writ petitions also, my lord, the admitted position was that, my lord, they have admitted that, my lord, part and parcel of land has been allotted to APDC. So it is a clash, my lord, between the private interest and the public interest, number one. Number two, my lord, this speaking order, my lord, lordship has just now seen, my lord, at page, before that, lordship may kindly come, my lord, to page, my lord, 29. And just draw, my lord, attention to some of the documents enclosed with the writ petition.
Yes.
Page 29. Now, authorities, now since Salakuddin is holding the field, the revenue authorities cannot straight away issue a section of, my lord, Rule 18 notice and then say, my lord, that you have to evict. They will have to be given whatsoever may be the nature of possession. One has to give them a notice in the nature of a purpose as to why you should not be evicted. If you have any bona fide right of claim raised, you can do so, and therefore giving them a right of carry, which as per this notice, my lord, 29 appears to have been done. Number one. Number two, my lord, thereafter they have filed
This is regulation 18 notice.
Yes.
Rule 18 notice.
Rule 18 to notice.
Now, both Salakuddin, my lord, the authorities are now required to give them a notice in the nature of a purpose. Whatsoever may be the, my lord, nature of eviction, my lord. Except their land and other lands are excluded, my lord.
But how did the court differentiate between 18.2 and 18.3?
18 to 18, my lord, 18, my lord, if they have any, my lord, any semblance of right, meaning they have, my lord, if the authorities themselves has, my lord, allowed the writ petitioners on the strength of any written instrument, my lord, that you remain here for some time. Then, my lord, if the authorities want to evict them, then, my lord, 18C will come into play. Otherwise, my lord, for encroachers and for all wrongful occupants, my lord, 18.2 is applicable. Now, in Salakuddin, my lord, it has been decided, my lord, by the division bench of this honorable court, my lord, that if you have to give notice, my lord, for any eviction to be done in pursuance of Rule 18. The issuance of notice is a condition precedent. And also, my lord, the notice has to, my lord, give them an opportunity of hearing.
Okay, that has been done. That we
Yes,
have done.
It has been done. And thereafter, my lord, Lordship will kindly see, my lord, the acknowledgement. My Lordship will kindly come to, my lord, page 50 of the writ petition. Kindly see, my lord, we have followed the due process of law. There is
Yes.
no flaw. Page 50.
Yes.
This is one of the acknowledgements. We have received all these documents, my lord. Kindly see, my lord, 50. This pertains to one of the writ petition. My lord, Xerox copy of voter ID card, Xerox copy of Aadhaar card. Now, after bona fide claims, so you are directed to appear under silence so and so. Ample opportunity has been given to them.
Yes.
Then Lordship will kindly see, my lord, the speaking order, my lord, passed by the circle officer. Now, this is a preliminary order, my lord. Because finally, page 62, Lordship has not seen it, my
Yes.
lord. Page 62.
That is qua the application for settlement, settlement.
And taking an overall view of the matter, overall decision of the matter, the DC has now passed the final speaking order. One of the speaking order appears at, my lord, page 83. So may kindly come to page 83.
Yes.
Page 83, Lordship will kindly see. This is a speaking order passed by the district commissioner. Now here everything has been called out. The fact that, my lord, so cause was issued, they have given a response to the so cause, and they have also applied, my lord, for getting settlement, and all the documents have been examined, and their my lord, statements have been recorded, and thereafter, my lord, the provisions of land policy have been discussed, and then finally, my lord, kindly see what is the, my lord, the final outcome of the speaking order. Now, therefore, I see Dibakar Nath, IAS, District Commissioner Dhubri, in exercise of the powers conferred under Rule 18 of the Settlement Rules, came under Assam Land and Revenue Regulation 1886, and the relevant provisions of land policy of Assam do
No, Mr.
hereby.
Bhattacharya, this is with regard to your section 18 move under the for eviction. But their prayer for settlement has been rejected.
Yeah, prayer for settlement has been rejected, and it has merged into this speaking order.
No, rejected. He
Yes.
is trying to make out a case that there is dichotomy. First, you say that you are not in possession.
Yes.
At the same time, you give a notice to vacate.
No, possession disputed means, my lord, we are disputing their possession. It may be so written, my lord, but the word dispute hereby means and connotes, my lord, that your possession is disputed. We are disputing your possession, thereby you don't have any right. So we are raising a dispute. If you have any right, okay, you fine, you stay there. You don't have any right. And dispute cannot be, my lord, interpreted in all this manner, my lord, the 3 generations, all these things. It may be so, my lord, that the authorities have used the word dispute. Dispute per se, my lord, taking into account the factual
No,
basis
if
of the case.
let us go by the plain meaning.
Yes.
The moment you issue a notice to evict, to
Yes.
vacate,
Yes.
that means it presupposes that somebody is in
Somebody
maybe
is there. Yes.
maybe it's an illegal possession.
Illegal possession.
Let us
Yes.
give all benefits of doubt.
Yes.
It's an illegal possession.
Illegal
But possession as such
Yes.
is not in dispute. The fact of possession is not in dispute.
My lord, that
The legality may be a disputed proposition.
Yes, my lord, that to that extent, my lord, that illegal possession which the lordship has just now said, perhaps, my lord, that ought to have been incorporated there. The word dispute means, I have taken instructions from the district commissioner, my lord. The word dispute hereby means, my lord, that their possession, you cannot be in possession. We are recognizing that you are in possession, but you cannot be, we are disputing. So that dispute is raised. And kindly see, my lord, against this order, specific alternative remedy is available, my lord, under 147. Because if this at all, my lord, tomorrow, if this court has to interfere and examine this speaking order, all the factual matrix has to be gone into, my lord, which cannot be done under 226, my lord. In 147, my lord, kindly see, regulation 147, my lord, of the Assam Land Revenue Regulation, says, authority to whom appeal lies to this under this regulation as follows: to the board from orders, original or appellate, passed by a district commissioner, settlement officer, that clinches the issue, my lord. How can, my lord, 26 court, my lord, delve into this, my lord, questions of fact, number 1. And number 2, kindly see, my lord, this writ petitions, how, my lord, this has been defined at a haste, my lord. Kindly come to the prayer portion, my lord, at page 25.
Yes.
Page 25 of the writ petition, my lord. Page 25, 26, and 27 are the prayer portion.
Yes.
this, my lord, to 26/5, my lord, speaking order passed by the deputy commissioner, my lord, on 2 days, 26/5/2025 and on 2/6/2025. Both these speaking orders passed by the district commissioners are not under challenge.
Yeah. 2/4/2025 and
2/4, I'm speaking of 2/4, I'm saying of 2/6/2025. Page number 83, which lordship has just
26/5, not 26.
Yeah.
26/5.
26/5, and then also my lord, 2/6 also lordship will find at page 76. Kindly see my lord, page 76. Page 76. 2/6. 2/6. Page 76 is the order dated 2/6/2025. Identical order, my lord, in respect of some of the other petitioners.
Yes.
Now, these orders passed by these final orders, speaking orders passed by the district commissioner dated 2/6/2025, or for that matter, my lord, the order dated 26/5/2025 are not specifically put to challenge here. In a very hurry, my lord, I can understand if the petition had been filed. But at this stage, my lord, if at all, my lord, they hesitate, my lord, maybe please to issue notice, but my lord,
Yes.
my lord,
Lordship,
strongly
so far as
object
your
and
lordship
intend.
that is concerned, your lordship may kindly come to page 26 prayer number 3, your lord.
Yes.
Issue a read in the nature of surgery, causing and setting aside the speaking orders
Issued by the
issued
petitioner.
by the issued, so that it should have been your lordship,
Have-
rejecting the causes shown by the petitioners as regards why no action under rule 18(2) of the settlement rules under the
I think
Assam
some blame you have to take,
lordship. Annexure 5
and you
series,
can
your
take the blame
lord.
only by declining to pass an interim order.
Lordship, your
Okay,
lordship will kindly see, your lordship, that Annexure 5 series is very specific, your lord. And its Annexure 5 series includes from page 74 to even your lordship, both these two orders. Now, your lordship will kindly see, your lordship. This is your lordship knows very well, your lordship. I don't need to reiterate before at least this honorable court that Article 226 has ample power.
No, we are not on those technicalities. We are not on those technicalities.
Lord.
We'll be,
And
last,
in fact, your
we'll be the
lordship,
last court to go on those technicalities. But substantial provision, yes, very much.
Lord, and your lordship will kindly see, your lordship, that at the end of the day, your lordship, these orders, your lordship, passed, your lordship, based on wrong premises, your lordship, in both ways. Ultimately, what is submitted by my learned friend, your lordship, that there is a report of the LCR, your lordship, revenue authorities, based on that, let them produce at least that.
And what about the appellate forum?
No, so far as that is concerned, your lordship, since I have already submitted, since the other petitions preferred by the petitioners are presently pending, wherein they have filed.
There was no
No.
cause of
This
action
is
there.
different.
Now here there is a
That
specific cause of
was,
action.
your lordship, there we have raised all these points because your lordship will kindly see, and finally, your lordship.
But
they-
there was no final orders in those cases.
No,
Now
that
here there is final orders in the form of either 2/6 or 26/5.
lordship.
Yes. In those petitions, these final orders were not there, my lord.
And your lordship will kindly see, your lordship is not required to go into the other factual aspects. My whole case is that it is against the reasoning given by the authority, revenue district commissioner, your lordship. It is against the what is there in the land policy, your lordship. That is my case. That the foundation is when wrong, your lordship. As a court of equity, your lordship can always interfere, your lordship. And at the end of the day, your
May not be
lordship.
a case for interim order.
The lordship will kindly.
We will go by the what are the relevant factors taken into consideration.
And your lordship will kindly see,
It's only the
If-
decision making. We may not go to the merits of the decision.
your lordship will kindly see.
Vis-a-vis the requirement of the land for APDCL.
And your lordship will kindly see, from that also your lordship will kindly see that the allotment of the land has taken place earlier to the rejection of our claim, your lordship. That itself shows that everything already has been made up, your lordship. What ought to have been the procedure, your lordship? First you reject our prayer, then allot the land. But here is a case, your lordship, allotment was done, your lordship, prior to rejection of our claims, your lordship.
Yes, APDCL is a party here.
Yes, your lordship, they are part, and your lordship.
They are the beneficiary.
Beneficiary.
They'll not be have much of a say now.
Lordship.
Maybe later on.
And in fact, your lordship, what will be the bona fide claim, your lordship? That has also been discussed in Salekuddin, your lordship. Once, your lordship, the bona fide claim, the right of settlement under your lordship land policy is a bona fide right, your lordship. That is what the Salakuddin has held. If that be so, your lordship, they will have to show in the order that I do not come within the purview of land policy, your lordship, specifically for this purpose. The ground they have shown, your lordship, apparently is in contradiction with what land policy has said, your lordship. Based on that, your lordship, in my humble submission, your lordship, this is a case, your lordship, wherein this honorable court, your lordship, otherwise your lordship will see that these people will be evicted. Eviction from your lordship, reserved land, your lordship, I can understand, your lordship. These people are residing there. They have the documents, they have place that has not been taken into consideration. Your lordship may call for, ask them to submit the report, your lordship, and pay them some protection, your lordship.
As Bothakur learned.
Immediately on reopening, this matter may come up, your lordship, let them produce, and till this period, your lordship, some protection may be given, your lordship, and heaven will not call for them, your lordship.
Petitioners.
These people are there for all these years, your lordship.
As per the facts projected, the petitioners are landless persons residing on government khas land in the Charua Bakhra jungle block under the Sapor revenue circle in the district of Dhubri. Full stop. They have claimed of residing over the plot of land for over 25 years and had applied for settlement of the land under the Assam Land Policy 2019 through Mission Basundhara scheme. Full stop. However, wide speaking orders dated 17/5/2025, the applications have been rejected. Full stop. It is also the case of the petitioners that before such rejection, land of about 2,258 bighas have been approved for allotment to APDCL for a power project. Full stop. However, even prior to that, in the meantime, the petitioners have also been issued notices under Rule 18(2) of the settlement rules under the Assam Land and Revenue Regulation 1886, requiring the petitioners to show cause. The responses were filed, which however has been rejected. Wide speaking orders dated 26/2025 and 26/2025.
Lordship, may I leave your lordship?
Yes.
Deep complex.
Let notice be issued, returnable by 4 weeks. 3 R. Borpujari Revenue 1,
One, my lord.
2, 3, 4, 5, 6 is Endas, and KP Pathak for 7. Para. Extra copies. Para. 3. Bothakur Learned Council has prayed for an interim order. Para. The same is, however, resisted by the Learned Council for the respondents. Para. While Sri Bothakur has tried to make up a case that the rejection of the prayer for settlement read with the eviction notice would show a dual stand of the respondent authorities. Para. On the other hand, Sri Borpujari, the Learned Standing Council, has submitted that apart from the procedure laid down in law, including the order judgment of the division bench in the case of Mohammad Salekuddin, WPC 1057 of 2022, comma, the land is required for constructing a project of the APDCL, which is 1 acre 6 acres, 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 1 ac directly connected with public interest.
Public interest.
Para. After consideration of the same, comma, this court is not inclined to pass any interim order at this stage. Yes.
According to 47.
It is also, it is also contended that there is a forum, appellate forum, for which a writ petition may not be entertained. Okay, but unlisted.
Obliged.
Huh? নিদিলে নেকি? Okay. Okay,
I'm so obliged.
wish you all a very happy holidays.
Obliged.
আজি 27 তাৰিখ ন? আজি 27 তাৰিখ।